this presentation. We will give you some time for questions in the end, but if you have any question during this presentation, please raise your hand and we'll take them as we go. So my name is Caroline Falconer. I'm the Secretary General of the SCC Arbitration Institute in Sweden, and I'm here with
Jake Lowther, Specialist Counsel, as Malin said, here at the SCC Arbitration Institute in Stockholm, and we're very grateful for the Swedish Army in China for having us today.
Yep. So let's start. Let's see if we can do. Yes, yeah. Here we go. So first of all, our agenda for today, our plan is to start a bit on who we are, the SCC. Who are we and what do we do? And then arbitration, what is it? When to use the different dispute resolution methods. Key components of a dispute resolution clause, what to think about there. Very practical tips, I can promise you that. And in the end, the tips and tricks for drafting the perfect clause, what to think about.
Yes, and we will try and save some time also at the end if you have any questions. So please do, during the session, if you have any questions, save them for the end. So if we start with who we are, well, you know now us personally, which is very nice, but the SCC Arbitration Institute, well, we are an independent department of the Stockholm Chamber of Commerce, a very important aspect of our work to be independent. And that is very important for what we do, which is offering a neutral platform and an impartial process for the resolution of commercial disputes from all over the world. And we, in the Swedish way, we dare to say that we are arguably the world's most modern arbitration institute. But in Sweden, we tend to add a nice caveat just to say that we're not too boastful. But I think, we would be remiss not to share how modern and progressive we are in our management of arbitrations and dispute resolution in general.
And if we are modern today, we still have a very long history. We were established in 1917, and in those first 40 years approximately, we only handled disputes between members to the Stockholm Chamber of Commerce in Sweden. Then in the 70s, we became very international quite quickly, and the SSC was included in an agreement, a trade agreement between the US and Soviet Union then. And more interesting for this audience is in 1984, we signed a cooperation agreement with the China Council for Promotion of International Trade. And since the 80s, we've seen quite a number of Chinese parties in dispute with foreign parties coming to the SSC for resolving disputes. And in the 90s, since the 90s, we've also been handling investor-state disputes, arbitrations between states and investors.
Exactly. And I think it's also worth just adding, Caroline, you were just in China, and in fact, the 40th anniversary of this signing of the cooperation agreement, we did a renewal with CETAC in China as well to commemorate this well, at the time, certainly very historic occasion.
Yes, we did. We did.
So if we're looking more concrete in what the SSC's work is looking like today, we are very pleased that from, as Caroline mentioned, a very humble domestic Stockholm-based small number of cases, a handful, to over 200 per year. Last year, we were very pleased to have 204 cases registered during the calendar year. And this is very international, so parties from all over the world, including China. We also, in line with the Swedish way of looking at things, are trying very hard to make sure that we have a balance of arbitrators, of people working with us, that it's not the historically very pale, male and stale group of people working in this field, but that it is more diverse, which we think leads to better results for the parties, for the users of dispute resolution. So we have the historical East-West connection, so whether it's the former Soviet Union states or of course China and the Far East as well. But as a result, a lot of energy-related disputes will come to us. Energy, but also M&A, IP-related, even in some cases employment agreements. And one thing that we are also very, very proud of is that the majority of our awards are rendered within 1 year. So especially when we are comparing to the Swedish courts, for example, this is a very positive statistic that we are very keen to make sure people are aware that if you come to us, you are going to have your results within a much faster time frame if you have to be in a dispute.
And in addition to that, it's also interesting to see what kind of disputes we have, and the year, well, 2023, when we gained these statistics, we're looking into last year's statistics as we speak. But in that year, our average disputed amount was more than 30 million euro. So fairly large disputes, and we have. If we compare ourselves to the other market leaders, I would say that LCIA in London and ICC in Paris or seated somewhere else. I know that ICC is not being used much for Chinese parties, but if we compare to them, we usually see that they handle an award within 2 years, and we do it within 1 year. So we are doing what we can to be as quick as possible here.
Yes, and always following and benchmarking against, what is happening in this particular field to make sure that it's a good experience for the users.
So, exactly. Yeah. So if we have a look at these Chinese entities that we see here at the SSC, in the last 10 years, we've seen more than 30 disputes involving Chinese entities. We've seen counterparties from Brazil, Canada, Germany, Russia, UAE, and the United States, for example. So it's a quite diverse group of counterparties to the Chinese companies we see coming to us. For these Chinese disputes, we had an average amount in dispute of 39 million euro, which is more or less in line with what we usually see. A lot of mining disputes, a lot of disputes from the automotive industry and life sciences as well. But that's only a couple of examples. Awards, you are a bit quicker actually than other parties we have at the SSC. So awards were rendered in an average of 8 months or 7.8 months. Which is fairly quick for these large disputes, and especially when you have disputes with parties from two very separate countries, not two parties from the same country, when it usually takes a bit shorter time.
Yes, and just for transparency, those numbers don't include, or they are mainland China and not including, for example, Hong Kong.
No, exactly.
But if we've heard a little bit about the SEC's story. Well, I mean, why has Sweden historically been also internationally preferred? Well, the brand of Sweden is amongst the top in the world. I've been very happy to learn thanks to the Swedish Institute, which is now doing a review of its international branding. But amongst the things that we are most proud of, I would say, is our emphasis on the rule of law, a low level of corruption, and very independent judiciary with pro-arbitration courts. So the courts in Sweden, they know arbitration and they know how to take those cases. In fact, there's a special, if you have an arbitration related matter, in many of the cases you go in fact directly to the second instance in the Swedish court system. So you go to the Court of Appeal directly rather than to the district court. So the Swedish arbitration landscape is very arbitration friendly. And again, our Swedish way, we dare to say that it's a very renowned international arbitration institute here in Stockholm, which is usually a very good sign, which we'll also get to later if you are perhaps unable to choose the SCC or Stockholm, but it can be a very good sign for if there is another alternative in the negotiations. For those of you who know Sweden, you will probably also be aware that we often don't really know what our money looks like because everything is so digital, modern, and therefore it's often very quick and efficient here. And finally, there are very good local lawyers who know their craft, who really know arbitration as well. And this is both, smaller boutique firms, sole practitioners, right up to the big law firms here in Sweden.
Yeah. And we have a history working with Chinese disputes and Chinese clients at the local law firms. So I would say we have a very good competence when it comes to these issues as well. What's most important to these types of disputes, because that differ between different continents, different nationalities.
Absolutely. Right, then back to us again.
Yeah, so who does what at the SSE? So you find Jake and myself on that upper picture. That's a picture of the Secretariat. So the SSE is an arbitration institute. We administer the cases. You send a request for arbitration to us, and we administer it. We make sure that you get an arbitrator or an arbitral tribunal appointed, and we make sure that the tribunal will render an award in the end. So from our side, we take care of all the logistics around this arbitration. The decisions on who is to be the arbitrator in the case, that decision is made by the board, which is the lower picture. And they also decide on challenges to arbitrators, and if there's not a decision on the seat, the legal seat of the arbitration, or jurisdiction, prima facie jurisdiction issues, that is decided by the board as well. These decisions are supported by the Secretariat and prepared by the Secretariat, but the decision power lies with the board. And then the arbitrators, the persons who actually decide in the cases and render an award in the end, they are independent from the SSE. And if you have an arbitration at the SSE, you are not going to get a Swedish arbitrator per se in every case. We have arbitrators from, I think it was 27 countries last year. We have a very good understanding of the market and who does what, who's the competences there are out there, and who to choose for whichever dispute we have. But the arbitrators are rendering the decisions, and they are independent from us. However, they need to follow the SSE rules the parties decided on when choosing the SSE.
Yes, and I would just add that it's really the thing that the Secretariat and then together with the board spend probably most of our case administration really considering who is the right person for this particular mandate, and really considering all of the aspects of the case as well as the potential pool of candidates, and also considering what are the potential conflicts that we want to be avoiding. Even the dynamic on a tribunal of 3 people, we will be paying attention to. So it's really probably our most important task when we are administering a case.
Absolutely.
So a little bit more on the statistics. As you can see, in general, we would have an average of approximately 50-50 in terms of the split international, domestic. And by international, we mean that at least one of the parties has no connection to Sweden whatsoever. And many of those international cases have no connection, neither of the parties. So it truly is a very international place to work. However, on the other hand, it also can be quite a Swedish place too. So we need to be understanding both the domestic, the local market, the Scandinavian market, and the wider world as well. So it makes for a very dynamic place to be working.
And just to give you a picture of what we see at the SSC, we've had more than 87 nationalities at the SSC in the last 10 years. We actually had 3 new nationalities last year, so we have more than 90 this year. We haven't been able to update this picture. And in relation to China, we've had 31 disputes in the last 10 years.
And here you can see where those counterparties were, and we mentioned in one of the earlier slides, but it really is a very broad spread and covering almost all of the regions of the globe. So truly, you know, the work that we've done and our historical work with China remains an important aspect of our work today.
And yeah, the total amount in dispute involving Chinese entities, and that's excluding Hong Kong in our presentation, 1.19 billion euro. So quite large cases of large interest to the parties, of course.
And then exactly, we have also quite a spread of different types of agreements that are lying that are the basis of the dispute between the parties. But as probably many might imagine, there is the sale of goods, of course, and services happening between China and particularly the rest of the world. So it makes sense in a way that many of these cases we are seeing have some kind of connection to these kinds of transactions, but also more corporate law, the transfer of shares, for example, or joint venture agreements. But yeah, quite the gamut of different kinds of agreements that we see here.
And we were already told you about the handling times for disputes. Chinese entities or disputes with Chinese entities are generally quicker than what we see in the rest of our caseload. And almost 70% were handled within the first half year, which is for an international dispute very quick. And as you see, the average was 7.8 months, which is very, very quick for international disputes. But I know that this is what we see at Chinese institutes as well. We have a cooperation with a number of Chinese institutes, including CETAC, and the duration of arbitrations are shorter in China than it is in your European institutes, for example.
So clearly we are able to deliver in line with the market expectations also in China.
Yep.
So if we then, for those of you who aren't familiar with arbitration, generally perhaps heard it a lot. I mean, clearly we're talking about the resolution of a dispute and in a particular method. And in this case, what we mostly see here at the SEC is arbitration in some form. So it's a kind of private dispute settlement method that is taking place outside of the domestic court regime. And we've mentioned, of course, its speed, but it's also inherently very flexible. The parties make the agreement, and one of the other benefits that many prefer about arbitration is its confidentiality, or the possibility for the process to be entirely confidential and also private. In many jurisdictions, of course, we have open court. You simply cannot go to a hearing of an arbitration, just any time. But there are some arbitrations that have been made public, but this is not something that the SEC would do. It's something that the parties could, with their inherent flexibility, make that choice. One of the other benefits of having arbitration is that the process results in a final award, which is final and binding on the parties, and it cannot be substantively appealed. So if a party is not happy with the result, you cannot simply go and ask another court or another tribunal to render a different award, to cancel the first one. There are a few grounds that you can raise if there has been some kind of lack of procedural fairness, or where the arbitrator perhaps has gone outside of the mandate to determine the dispute. But these are very, very rare, and even rarer that they are successful. So if you are choosing arbitration, you could be very, very sure that you will get your award, and that will be the end of the matter. And certainly many parties, even those who aren't ultimately successful, at least they know, well, that's it. Now we don't have to think about it, and it was over swiftly. Why is that also really useful in arbitration, and particularly for those who are working in China, is that arbitral awards are enforceable in fact, it's over 170 countries. There is an international convention, one of the most successful in modern history, that is signed by, I think it's 172 countries at the moment, the New York Convention. And according to this convention, essentially you take an arbitral award rendered here in Sweden to China or to anywhere, and it needs to be recognized and enforced by that court according to this treaty. So as opposed to if you get a court judgment here in Sweden, this is going to be very difficult probably to enforce directly in China unless there is some other legal instrument that you can rely on. And there are very few of those. So.
And the question I went to China twice last year to give a number of different presentations, and the most common question I got was, well, the SSE award, will that be enforced in China as well? And the answer here is yes. We have seen that SSE awards have been enforced in China, in mainland China. And it does work in practice as well. The region we have a bit of a problem with, I must say, today is Russia. And all European institutes at least have a problem with getting their awards enforced in Russia at the moment, because they are using anti-suit injunctions and finding ways of not enforcing. But otherwise, it does work to have an SSE award enforced in all the countries we see in our caseload, actually.
Yes. When it comes to Russia, there was a recent SSE case that was enforced there, although one might also see a difference because the party seeking enforcement was Russian. But it is more of a challenging situation in certain jurisdictions. But I think the general consensus is that China has been a much more pro-arbitration and has definitely also wanted to become more pro-arbitration, because it really does help to facilitate. It's almost like an insurance for an investor, for somebody wanting to enter into an agreement with the Chinese party, that should something go wrong, you can end up in a neutral forum and have an enforceable result at the very end of it. But when we're talking about dispute resolution that is mandatory but outside of the courts, this is something that the parties must have agreed on at some point. So this could be in their contract. It could even, in theory, be after a dispute has arisen and they decide that they would like to have it resolved through an arbitral award. Of course, if you are already in a dispute with the other side, coming to an agreement can be more challenging. So we highly recommend that the parties put these arbitration agreements into their main contracts, but we will also come to that when we're talking about some of the tips and tricks that we have for businesses who are operating in China and internationally as well. And one of the other final most important advantages, particularly for business, is the fact that you can choose your own judge. You choose the arbitrator. And this is particularly useful because in some jurisdictions, you are simply assigned a judge if you go to court, and they may have very little experience of the commercial world. They may be mostly working with criminal law, for example. Whereas if you are in the middle of a large dispute, an energy dispute, for example, you might want somebody who understands the industry, the sector. It could be renewable energy, or it could be oil and gas. You might want a particular kind of expertise. Also somebody from a different part of the world. And this is what arbitration provides the parties, the possibility to choose. However, if you can't, this is where the institution can step in, and often we do. The default, for example, under our rules is we will appoint the chairperson of a case, or we will also appoint a sole arbitrator if there's only one and the parties cannot agree. So we can absolutely do it, but it is, we know, often preferred by the parties that they choose their own arbitrator. We suggest that we do a very good job of picking the arbitrators, so you can certainly rely on us if for whatever reason you don't want to appoint or cannot appoint.
And we do appoint Chinese arbitrators as well. We have our well, we're not restricted by any list, so we do have a database, of course, to have a good understanding of the arbitrators out there, possible to appoint for an arbitration. And we do have a number of Chinese arbitrators, and seen that in very many arbitrations in the last few years.
So
yes, so when to use the different dispute resolution methods. And these are the sets of rules that we offer, and it's very much the same in as you see at ICC or LCIA or in Dubai, for example. So what we've been speaking about up until now is arbitration, and that is, I would say, the flagship. We have a set of rules, and you can have either a tribunal of 1 or 3 arbitrators, and you have the toolbox at your feet, and you can decide how to structure the arbitration. It's a very flexible process. Then we have expedited arbitration, and that should be expedited. It's quicker. The majority of these cases are concluded within 3 months, which is very quick under our rules, and the rest of them within half a year. Yes. You only have 1 arbitrator, and you generally don't have a hearing either. It's generally a procedure in writing, but if you have a hearing, it usually takes maybe 4 months to conclude that.
One way that is able to go faster is that, in fact, before the arbitrator is appointed, the parties will have done the majority of their submissions beforehand. So you can, what we call, front load the case, so that as soon as the arbitrator picks it up, they can hopefully, with very little additional submissions, be able to render and award a judgment.
Yeah. And expedited arbitration is something you can find at most arbitration institutes. We've had it since the beginning of the 90s in Sweden. But what we see when parties choose between arbitration and expedited, they look very much to the value of the dispute. If it's a greater value, go for arbitration. And then you usually also want to go for 3 arbitrators because, well, it's always more, it can feel more secure to have the three members of the tribunal. If the value is smaller, if there is an urgency to get an award quick, then expedited arbitration is the way to go. And you can also, what was my thinking there? If you have a very easy, if you know that this contract will not render any complex disputes, it's a quite simple dispute that could be rendered under this contract, then expedited arbitration can be a really good method because you don't need to have that full-blown arbitration that will also render a larger cost, of course. So it's all about finding the most cost-efficient way to resolve a dispute. Yes. In the end.
And the parties have a lot of flexibility to be able to choose amongst these methods what is the most appropriate actually for my contract, for this situation. So it's really worth, considering what the particular differences are and how it might be more appropriate in the long run.
Yeah, absolutely. And when do they make this choice? When do they choose between the two?
Yes, well, we would definitely advise to do so, as mentioned before, when you are putting the contract together initially. And when we look at the SEC rules, we have these two different boxes here. And this is because under the SEC rules, you have to choose, However, we understand sometimes that it can be difficult to predict what is actually going to happen. Some contracts, it could be a very narrow dispute, or perhaps, it could be very complicated intellectual property kinds of questions coming in as well. Or maybe you can expect that should the worst happen and a dispute arises, you might be needing some documents from the other side to be able to demonstrate your case, which can take a longer time. So what you can do when you are negotiating your contract, this is a tip already, but we have devised these clauses that the parties can use on our website, copy paste, and we have so-called combination clauses where the default is the expedited rules, so the faster option. However, that should the parties want, or at least one of the parties want arbitration, then the SEC can take the decision if the parties are not in agreement. And the SEC will do so in one case based on its assessment of the circumstances of the case. So where are the parties from? What kind of subject matter? What kind of applicable law? How complicated do we foresee this dispute being? What is the value? But also there is the possibility to simply set an amount in dispute threshold. So if the case is going to be of less than €1 million in value, then it is default expedited. But above that, it could be arbitration that is the applicable set of rules. So the parties do have a lot of flexibility. And what we've tried to do is really give you as much, make it as easy as possible so that, regardless of your choice, you can feel confident that the right mechanism will be applied should the worst happen in your business dealings.
Yeah, no, exactly. If we go to the possibility to have an emergency arbitrator appointed, that is actually a possibility under both the arbitration rules and the expedited arbitration rules. So if you have a contract referring to the SSC, arbitration at the SSC, you will also have the possibility to appoint or to have an emergency arbitrator appointed. There needs to be an urgency to be successful in that request. When we receive this request, it's generally on Christmas Eve, it's Friday night, it's always off and non-office hours we receive them. Then we have 24 hours to appoint an arbitrator. This emergency arbitrator has then 5 days to render a decision. We see this with the Chinese entities being used. It's been used for the last almost 15 years now at the SSC.
Definitely. And very exciting when these cases come in. But I suppose one advantage there could be for businesses operating in China is we don't share many of the same public holidays. So, maybe the Lunar New Year, a request coming in then that would be not so optimal for a Chinese party, for example, wouldn't cause too many delays here at the SEC.
No, exactly.
But if we go on to mediation, many may have already heard of mediation, but this is even more flexible. It's a non-binding process where you have a neutral person applying either, say, a facilitative method where you're trying to help the parties come to some kind of a settlement, or is it remind me, is it assessment, and where you are getting a bit more of a hands-on person trying to herd the parties into some kind of settlement. And we know that mediation can save the parties in big and small disputes time and money, but it does require that both parties have a willingness to actually sit down at the same table and talk through the problem. And of course, we understand that this is not always going to be appropriate, and as a result, you may be needing a binding mechanism like arbitration. But we are seeing an increasing interest in using mediation, especially here in Sweden, where traditionally mediation has perhaps been more informally done by judges in the courts, but hasn't necessarily had a formal status like it has in perhaps common law jurisdictions like UK, or we know Hong Kong also. Many mediations take place. So
yes, absolutely. Maybe we're going to have some more information about the SSE Express as well. We're going to come back to that.
Yes, because that's quite novel.
Yes,
exactly. So the SSE Express is, having just mentioned mediation, here we are in a kind of hybrid between arbitration and mediation, where what the parties have agreed to is it is either contractually binding or perhaps could be resulting in the award, but it's also a voluntary process where you will have an assessment of the dispute, and this will be rendered within 3 weeks for a fixed fee. Also confidential, but the reason that the SSE Express was developed is because we saw that many parties were looking for a third way, not necessarily wanting to go through a full binding dispute resolution procedure that can take up to 6 months or even a year in some cases, but simply, what is the feeling of the judge, of the arbitrator? In this case, we call them a neutral. How would they assess this case, and what would the outcome ultimately be? And this SSE Express is particularly suitable when you have a kind of particular legal question, perhaps a contract interpretation, where the parties just simply cannot agree on what did we actually mean with this particular clause that may be very important for their business relationship over a longer period of time. But similarly to mediation, it does also require that the parties do want this business relationship to work. They have a willingness to work through it, but they just have very different views. And sometimes what you just need is a neutral person coming in, looking at the documents and quickly saying, it's this is the answer. So it's where you have perhaps a complicated but very narrow legal question that this particular tool is most suitable for. And it was really developed in discussions with the people who were using our services, who were saying, look, we just need this kind of service that operates a little bit in between. And what we've also noticed is that the users of the SSE Express also include public sector entities. So it's really being used not only by normal commercial businesses, but the full spectrum of operations in business and the public sector. So it's a very interesting tool, and one that the parties are increasingly considering using for their dispute resolution. But again, it has to be agreed on by the parties.
Exactly. So if we try to put everything we've just said into a table like this, you can see what we recommend, when to go to which of the methods. And this is of course our recommendation in relation to the SSE rules, but you can use this in relation to other institutes as well. Even if the timings will be a bit different then. Oh, sorry. So yeah.
So we mentioned costs before. Clearly, business is not about going to disputes. Your business is about so much more. And sometimes, a dispute might not even be worth to even proceed to some kind of arbitration or something else. One of the ways that we've tried to create transparency and predictability for users is with this cost calculator that we have on our website. Essentially, what is the value of the contract, or what is the value of the damage if you know, based on your estimate of it, and then by choosing which rules are applying in the case, how many arbitrators are there, you can get an estimate within seconds that can give you an understanding of, okay, how much is this going to cost here at the SEC? And of course, you can understand that this is considering just the SEC's cost and the cost that we will, the fees of the arbitrator. So we administer that part as well. And of course, the arbitrator needs to have remuneration for their rendering of the award. And what we've seen in our analysis of cases is that the amounts of these costs is a very, very small and increasingly small proportion of the overall costs. So what arbitration has been criticized for, if anything, it's that it's more expensive than filing a claim in court, because of course, you know, a judge, you don't pay their salary. However, the overall costs are such a small, so as to be insignificant amount, because it's really the legal fees that have the biggest effect on the parties. And this is where perhaps the parties also have a greater flexibility to perhaps negotiate with their legal counsel, you know, a deal that might be better for them. But as much as we can give the parties transparency, we have with our cost calculator. Yep. So now, finally, those clauses, yes.
How to write that clause, and we call it the midnight clause. This is often a clause in a contract that you think about the last. It's either boilerplate, you've copied it from another contract, or you add it from a template, the very last thing. So some key components in this arbitration clause or dispute resolution clause is you're going to choose your forum. Do you want to go to court, litigate future disputes, or do you want to go to arbitration? So that's the first main decision. Then, if you are choosing arbitration, do you want to do that ad hoc without an arbitration institute? That's a very important question, because in some countries you see quite a lot of ad hoc arbitrations where you appoint the arbitrators and they also handle the administration of the cases. So they take care of all the issues that can arise that we at the Secretariat otherwise handle. We stand for the institutional approach, of course, and that is prevailing at the moment in the world, I would say. Most arbitrations are institutional because you do have a number of benefits, the cost being one. You do have to pay the institution as well, of course, but you will get a shorter duration of the arbitration, and you don't have to pay the arbitrator to spend time on these administrative issues that the institution can do for them.
Exactly. What you are paying for really is the time and the certainty that someone is looking after this. And if you consider that if you're in a dispute, it's more difficult to then agree on the small things. Well, in the ad hoc, there's often a lot of these small things that the institution takes care of. And this suddenly is, if not the parties, if they cannot come to agreement, there's more work for the arbitrators as well. So again, more time, more cost involved.
Yeah. Then if you want to, you can also decide on the number of arbitrators. You can already in the clause say if you want to have 1 or 3 arbitrators in an arbitration under the SEC rules. Something that's very important is to decide on the seat. And if the parties are not deciding on that in the clause, the institute will decide for them. And the seat has a legal meaning. That is the home, the nationality of the arbitration. So what we usually see in SSC arbitrations is to have Stockholm in Sweden as a seat, and that means that the Swedish Arbitration Act will apply to the procedure. And if you challenge the award, that will be done in Stockholm at the Court of Appeal in Sweden. But you can choose any seat, and you can choose. We do see a number of foreign seats to us every year. I'm not sure we've seen Chinese seats in SSC arbitrations.
Not yet.
Not yet, but we have seen Singapore, for example. We have seen London quite a lot, Germany quite a lot, for example.
Yes.
And the important thing here is to choose a seat that is usually choose a country that is used to arbitration.
Yes.
So they have a setup to handle the potential challenge to the award. Then you choose which law to govern the contract, and that can be any law, and that is really freestanding decision from the arbitration clause. So you can have an SSC clause, a seat in Germany, and you can have English law, for example. So it's really a pick and choose, but that's of course a very important decision for the parties. And finally, language.
Yes.
Which language is the arbitration going to be held in? And this is a decision the parties can change when they start the arbitration, but that requires both parties' consent.
Yes.
What we see sometimes, and that is a cost driver, so beware, but what we see sometimes is that it's a bilingual arbitration. So for example, English and Chinese.
Yeah.
Or Cantonese or Cantonese and Chinese. But that will drive cost, because then we need to find counsel and arbitrators understanding both languages and so on. And there's a need to translate as well.
We do also see, for example, arbitrators saying, well, the language of what we write in our submissions will be, say, English or Swedish, but documents can be submitted in original languages such as Mandarin or Russian or similar. And then perhaps when we are appointing an arbitrator, we need to find someone who can read in these languages as well, or perhaps translations and interpreters will be needed during the proceeding. But this is again up to the parties and how they want to proceed.
Yeah.
One other thing on the seat, I know we're starting to run a little low on the time, but the seat is not also a choice on that you have to come to Stockholm, for example. So you could have the hearing if you want to have a hearing in China, in Hong Kong, anywhere in the world, if the parties agree and that is appropriate for the case. So it's a legal choice rather than any requirement to physically be present.
That's very important. Can you have the hearing online?
According to the SEC rules, yes, you absolutely can. And if the parties cannot agree on this, then it is up to the arbitrator to decide. And some of you might remember that there was a certain pandemic a few years ago. So this was actually one of the changes made to the SEC rules at the time to make this, what was in essence already clear, even clearer for the parties, that it is possible to go purely online if needed. And preferred. And of course, in this international business world, I mean, here we are. Of course, we wish we could be in Shanghai as well, but this is the next best thing. You will all receive copies of the slides as well, by the way, but here you can just see a map of some of the dispute resolution clauses that we make freely available on our website. And I think the title here will be linking you there, and you can choose what is going to be most appropriate for your agreement and simply copy and paste directly from the website. But we've tried to summarize some of the different things to consider, and what we are seeing increasingly is users choosing to have a combined clause in their agreements, because it gives you a bit of a best of both worlds if you aren't quite sure how this contract might end up. And in the case of mediation, one thing that I think we will be mentioning anyway is that it's important to not just have mediation in there, but absolutely as a non-binding possibility for the parties. It's definitely worth to consider.
And this is our the main arbitration clause we have on our website, and it's quite short, and we do always recommend the additions below. So make sure to choose seat, language, and governing law. But this is really what you can use for any institute. This clause can be used for any institute, not only the SSC. Exactly. But just make sure you choose an institute that can handle arbitrations.
Exactly. So with those recommended additions, the reason they are recommended is because they will save time for the parties if there should be a dispute, because otherwise the SEC, for example, needs to make the decision on the number of arbitrators. So and here is that combined clause that we had mentioned. But if we skip now to those tips and tricks, because we know we are almost out of time. So here we go. Some of the most important things that we recommend that businesses avoid when they are negotiating their contracts is these mandatory escalation clauses that were I sort of foreshadowed a little bit before, where you have to have taken a particular step. For example, the party CEOs need to have negotiated before you can go further. You know, the more that is in these dispute resolution clauses, the more that you can just dispute about the dispute. And this is why when Caroline said it's quite a simple, short clause, this is because it has the bare essentials, and many lawyers have spent many hours refining, cutting, and perhaps it's also the Swedish way a little bit as well. Less is more, I think we would often say. Another thing that we avoid, you know, we mentioned, of course, that the appointment of the arbitrators of the tribunal, this is very important for the parties, making sure that you have the right competence on the tribunal. But the more you write again in this clause, the more difficult you can make then for example, us at the institution. We can see roughly what is needed. You, of course, have every opportunity to comment on the kind of candidate that the institution should appoint. But the more that is actually in the contract, the more problems that can arise in perhaps finding some unicorn candidate that simply isn't available or isn't out of conflict and so on. We also tend to advise avoiding so-called multi-forum clauses. So this is where you might say that the contract, any invoices related to this contract that are not paid, well, this will go to the local court, for example, up to a certain amount. And then after that, you go to arbitration. And it may be that a dispute starts out in one forum and then needs to partly move elsewhere, or you might want to combine certain questions. But if you have to split things up, again, this is delay, this is time and cost that really is not what you're interested in. You want to be getting on with the business of doing the business.
And we also see that you can have a clause saying that if the Chinese entity requests arbitration, that goes to CETAC in China. And if the German counterparty requests arbitration, that goes to the SSC. That can be a very tricky situation where you have disputes between the parties. So please don't do that. And the most common mistake we see is, of course, incompatible clauses in several contracts between the same parties. Make sure you have the same clause, the same institute, or going to court with all your contracts. Make sure you compile everything into the same method at least.
Yes. So, for example, you might have general terms and conditions, and then you might have another contract coming in on the top of it. And again, the less that you are disputing over a dispute, the better.
Yep. So maybe the final
slide. Yes, 'cause we have a couple more, but we appreciate we don't have so much time.
So let's open up. Do we have any questions?
And we can also take them by email or later if people are too shy to speak.
Absolutely. We're happy to take, yeah. We're happy to take questions by email.
Thank you so much, Jake and Caroline, and share the email addresses. And this webinar has been recorded, so my colleague Jonathan will send out the slides and the recording to you all. So yes, anyone has have any questions? And we have a couple of more minutes. And also, thank you for attending. A big thank you to Jake and Caroline again. Very interesting. And please, our events, you can scan the QR code or visit our website. Yes, do you have anything else you want to share, Jonathan or Jake or Caroline, before we end this webinar?
No, but thank you very much again for having us, and we look forward to continuing the conversation both with Swedcham in China and of course all the participants as well.
Yeah. And we didn't say that, but we have our rules and our clauses are available in Chinese.
Yes.
So if you want to have them in Chinese, please go to the website and you have everything there. And we also have recordings of me actually speaking Chinese. It's of course translated, but you have this presentation more or less in Chinese.
Ah, great to know. Yes.
Super. Well,
thank you so much.
Yes, a nice evening, those of you in China, and a nice continuation in your day here in Sweden.
Yeah, thank you so much, everyone, and thank you, Jake and Caroline. Have a nice day.
Hej då.
Bye-bye.
Hej då.
Bye.
Thank you. Bye-bye.